Mr. Bonfant is currently not competent to stand trial, and that inpatient treatment for competency restoration would be warranted. Is there any other evidence with regard to competency?
Not from the state, Your Honor.
At this time, then, I am going to find that Mr. Bonfant is not competent to
Can I
stand trial. Hang on, let me say what I need to first, and then I'll let you.
Illuminati, man. I got the government microphone chip in my left knee, my right hand hollow. I've been to the hospital. I understand the courts, man. George Bush know me. I'm not lying about nothing. I testify and take a lot of tick tests. I'm innocent. I got the right to freedom of speech, man. I'm asking for probation, 2-year cap. So I can go home today because these people on the Illuminati application on their phone is manipulating the government system through my chip. I do hear voices. I don't take medication, and they force you to take medication and join S. Dunn Behavior Center. Coach Lewis know me. I was sitting here. I had an aggravated robbery job. I shot a 9mm 2 times, one doorway.
So, Mr. Bonfant,
German Daly shot that 45.
Go back with the bailiff. You can go with the bailiff.
Talk, man. I'm sorry about that.
All right, I'm going to find that Mr. Bonfant is not competent to stand trial. Make
Sacrifice him, man.
that inpatient restoration treatment is warranted. Order that he be. All right, Mr. Parker and Ms. Melfino, we're gonna, I think they're here with.
Ochoa.
I'm not questioning the definitely, I'm curious.
Good morning.
Wow.
Good morning, Mr. Bell. Can you hear me?
Yeah, I can hear you.
Yeah, good. Okay, so I can hear you too. So I just wanted to, you can see here in the courtroom, Mr. Parker, your attorney's here. And also Ms. Malfino with the state is here. And I have already started this hearing previously in cause number 14-18993. Mr. Bell was found not guilty by reason of insanity quite some time ago for the offense of aggravated assault against a public servant, has been in the Russ State Hospital, and I have received requests and information that a step down type facility would be in Mr. Bell's best interest at this time. And so, Mr. Bell, I just wanted to talk to you a little bit real quick. I went and looked at the house where you would potentially be going if I allow this. And I really wanted to ask you a little bit about what you have discussed with the social workers there and what your expectations are if you go. Do you know anything about the place where you're going?
Similar to a boarding home, I'm halfway house, like community care home, something like that. But it's a group home.
Right. So it's actually, yeah, and it's very, very nice home. And there would only be, I think, maximum 2, maybe 3 of you there. So it's not a big group home. It's just a regular house in a neighborhood. And so the most important thing to me, Mr. Bell, is that you continue with your medication. Do you understand the importance of that?
Yeah, if I take my medication, I do a whole lot better than trying to go without it.
Right. So if I let you go live at this house, I want to make sure you understand that if you miss your medication, even just one time, there's going to be someone there always, and they'll make sure you take your medicine. And if you don't take your medicine, either refuse to or skip it for any reason, then they'll let me know that, and there'll be an order sent out, a warrant for you, and you'll be right back in jail and probably right back in Rusk. You understand that, how important it is?
I understand that.
Okay. Also, obviously there's rules there, just like you've been following at Rusk, and you would be required to follow those. You understand that as well?
Yeah.
And do you have family here?
Something like in Beaumont?
Yeah, you have a sister around here?
But my second to the oldest sister lives in Beaumont in a brand new house. My little brother stay in an apartment, the baby of the family, John Glenn. He lives in Beaumont.
So it would be nice if you would be able to see them. They could come see you. I do want to make sure you understand, though, that you couldn't go stay with them unless you had permission. You have to stay and live in the house, and you have curfews and things like that. You understand? You're okay with that? Okay. All right. Is there anything you can ask Ms. Malfino or Mr. Parker?
I don't believe so, Judge.
All right, so I think, Mr. Bell, what I'm gonna do, I've only done this a couple of times, and you probably even know the ones that I have done this with there at Rusk and let out, and they ended up right back there a few years back. And so you probably know who I'm talking about. I don't want that to happen with you. I think it sounds like you're a great candidate for this type of home, and so I'm going to allow it. And so I just want to make sure you and I had this conversation that you know that you have to follow every single rule exactly like they say, okay?
Okay.
And this will give you a little more freedom to be here locally where you can see family and things like that as well. All right?
All right.
So we'll get the paperwork done. I don't know exactly when all of it will take place, but it'll happen very soon. I am going to find at this time that treatment is still required, but that a lesser restrictive environment is appropriate. And I will set out an order with all of those rules with regard to medication and things like that for you to follow. And as soon as all that's done, they'll work out getting you transferred here, okay?
Yeah.
You good? Good morning. Are you Elazar Stanberry? Elazar, Mr. Stanberry, this is 26 DCCR 0174. You're charged with the first-degree felony offensive murder. Mr. Burbank, what is the announcement?
Filed a rejection. Today's charge, the offer was 40 years.
All right, let me go through that. So, Mr. Stansberry, what you're formally charged with is obviously the first-degree felony offensive murder. And that is from November 7th of 2025. And what that means is that if you go to trial and you're found guilty, the range of punishment would be a minimum of 5 years up to 99 years or life in prison. Do you understand? And I have here on the tablet a document that you've signed entitled Plea Bargain Rejection with Mr. Burbank. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 40-year term in prison. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter a plea of guilty. You understand all of that? And you want to reject that offer and have your case set for trial. All right, we'll get that done. Mr. Smith, is there any reason to believe that that offer would change?
I don't think so, Judge. This is actually Luke's case. I was just covering for him this morning, but by all accounts, there will be no reductions.
Nothing, as far as you know, not waiting on any type of discovery or
I
evidence?
think there's
Got it all.
nothing that's standing out that
Okay.
is going to delay.
All right, so I want to make sure you understand also, Mr. Stansberry, that after today, I will not accept this agreement. The only reason I would accept this or something different or better would be because some different evidence or information came to light that your attorney and the state's attorney didn't know at this point. You understand? All right, we'll get it set on the trial docket. Mr. Burbank will be in preparation for trial. Oh, did I miss a whole page? I did. There we go. 1, 2, 3, 4, 5, 6, 7, 8, 10 cases. Good morning. Are you Brandon Bonton?
Yes, ma'am.
And this is cause numbers 26 DCCR 0277, 278, 279, 280, 281, 282, 283, 284, 184, and 0490. And Mr. Bonton was examined for competency to stand trial by Dr. Grimsley. I received that report. I'm going to take judicial notice of the court file in all of the cases. The report is dated April 14th of 2026. The finding in that report is that Mr. Bonton is currently not competent to stand trial, and that inpatient treatment for competency restoration would be warranted. Is there any other evidence with regard to competency?
Not from the state, Your Honor.
At this time, then, I am going to find that Mr. Bonton is not competent to
Can I-
stand trial. Hang on, let me say what I need to first, and then I'll let you.
Freemasons Illuminati, man. I got the government microphone chip in my left knee, my right ain't hollow. I've been to the hospital. I understand the courts, man. George Bush know me. I'm not lying about nothing. I testify and take a lot of tick tests. I'm innocent. I got the right to freedom of speech, man. I'm asking for probation 2-year cap. So I can go home today because these people on the
That's not
Illuminati
right.
application on their phone is manipulating the government system through my chip. I do hear voices. I don't take medication, and they force you to take medication and join S Done Behavior Center. Coach Lewis know me. I was sitting here. I had an aggravated robbery job. I shot a 9mm 2 times, one doorway.
So,
Cameras,
Mr.
defended
Bonson,
itself.
you can
Jeremy
go
Daly
ahead.
shot that 45.
Go
Him
back
got
with the
that clip.
bailiff. You can go with the bailiff.
Talk, man. I'm sorry about that.
All right, I'm gonna find that Mr. Bonson is not competent to stand trial, make. the
Sacrifice
finding
him, man.
That, inpatient restoration treatment is warranted, order that he be. Good morning.
Good morning.
You are Donald Cogdill,
Yes, ma'am.
and this is 26 DCCR 0005. Mr. Cogdill was previously in court, entered a plea of guilty to evading arrest or detention with previous convictions, and also pled true to prior convictions, making this offense a second-degree felony. The agreement was for a cap of 8 years in prison. I received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor, and I want to commend Justin Riley on what a great report he wrote. He really did.
Ms. Malfino,
I have, Judge.
any additions or corrections?
None, Your Honor.
Judge, obviously, I am aware that the criminal history is of concern to the court. As you know from the indictment, the underlying offense itself is a state jail felony. And the offer was made just predicated on the nature of that offense with these priors. I'll defer to whatever you think is appropriate, if in fact you think 8 is enough. No, I'm intended.
So I want to make sure, Mr. What's the status with parole? You're on parole, correct?
Yes.
Have you had a hearing out at the jail? Have they come to the jail for a hearing? Have you talked to anyone with parole about this case?
Somebody called over there. I don't know who it was.
Okay.
There's something about parole, not parole, but like, I don't know, I don't understand what he was saying.
Okay, there's a hold on him, correct? Sure. Mr. Parker, you may proceed.
I've had this same issue trying to figure some of this stuff out, Judge. I've talked to him, and the facts of this case, I mean, to my understanding, what the probation calls it, he was living in a transitional house. And I've talked to him about where he's going to live. He intends to go back to the transitional house, and he was working there in the kitchen. And the facts are that he was out. It started pouring down rain. He went to a house. He was on a back porch that he thought was vacant, and he was on the porch getting out of the rain. And 5 cop cars pulled up. And as he says in his report, I asked him, "Why did you run?" And he said, "Well, 5 cars pulled up and I got scared." And I mean, and I've heard that a lot, but I mean, I think he's sincere in that. Not that it's justifiable, but that's what happened. He wasn't trying to break in the house, and that's what happened in this case. And I would point to the probation officer that thinks he might respond better to a structured guidance than to extended incarceration. It's in the top paragraph on page 5, the last sentence. And that's kind of my position. I think the last time he was in trouble, well, he's obviously been incarcerated, but was in 2017. I clearly think that the probation office has pointed out everything that's about him thoroughly in this report, and just going back to his childhood, how he's raised and how he's lived, and his educational standing and his mental capacity. I think he's competent, but it's not as high as a lot of people that are out there, and he struggles to get by. But if it's possible, I think we would request he be allowed to be placed on probation. Understand the question about parole. Otherwise, we ask for on the lower end.
Small Fino.
Judge, I really don't have much additional. I don't think he's a suitable probation candidate, although inference can be made from the offense itself that could have very easily turned into a burglary. I'm just glad we're not here on an offense involving him actually being inside someone's home or involving a child. So But based on the mitigating factors pointed out by Mr. Riley, I'd ask the court to consider the 8.
So, Mr. Cogdill, I appreciate your attorney's argument. I understand, I can see that there's some issues, cognitively, however, there's no doubt that you understand what's going on, right?
Yes.
Yeah. So you've been sent to prison 6 times and you're currently on parole for 3 burglary of a habitations, delivery of a controlled substance, evading arrest or detention with a vehicle, and then a indecency with a child. And it makes no sense to me that you were on parole and had opportunities through parole to get any help that you needed, and you didn't take advantage of that and were out doing whatever you were that you shouldn't have been doing and then ran. So at this time, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of evading arrest or detention with previous convictions. Find those prior convictions true that you pled true to. Sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, you can go back with the bailiff. Review that report.
We have your own.
Any additions or corrections? All
Not from the defense.
right, Mr. Rojas, you may proceed.
Thank you, Judge. Obviously, Judge, when you look at this PSI, what stands out is criminal history. It looks rather lengthy on paper. I'll point out to the court that most of the misdemeanors anyway are trespassing cases. And I would guess, and Mr. Johnson tells me this is a case that most of those, because he was homeless, didn't have any place to go. And if the court knows if you're homeless and don't have any place to live, you're gonna probably pick up some trespassing cases. He does have 2 prior cases which where he got probation and was revoked. I understand that's not a good track record when we're here asking for probation. I will point out that I think the most or the felony probation case was in 2000. And the one where he was revoked on the misdemeanor was in 2020. So a little bit of time has passed between those 2. As far as this current case is concerned, if you look at his statements, he looks like he was stealing food and clothes, necessities. $72 worth, which would ordinarily be a misdemeanor, but with the fact that he already has his 2 prior theft cases, and the other felony case was bumped up to a 3rd degree. He's asking for probation, Judge. And again, the felony history anyway is from the last felony case is from 2003, it looks like 23 years ago. He tells me that prior to being arrested, he was working for a church, being paid on a daily basis. I also did some work for a car dealership out in Silsbee. He tells me he can go back to both of those jobs. The car dealer, he doesn't have transportation, but the car dealership came and picked him up and brought him back and forth to work. So that shouldn't be a problem as long as that job is still there. According to PSI, he's going to be living with his mom. So we're asking the court to consider probation, a deferred probation term. If the court is not inclined to do probation, I would ask for the minimum term on this 2 years, given the fact that things he was stealing, necessities, and the length of time since his prior felony convictions.
Thank you, Mr. Rojas. Ms. Malfino?
Judge, I don't think he's necessarily not a candidate for probation, I think it should include safety, in my opinion. If the PSI reads as if he expressed interest in that, I would like to ask him if he really wants to take advantage of that. Otherwise, we're just gonna be back here in a year on the same situation.
And I apologize, Mr. Johnson did want to speak to just so whenever.
All right, go ahead, sir.
So the first charge I ever got, it was in 99. I did my time. I got out. I had a family. I lost it because me and my wife got into it when she took my kids to Louisiana. I not gave up, but I became homeless. I got all them trespasses. Then I started stealing food and clothes out the store. But being in the county for the months I've been in there, I see it was wrong. You know, one thing about me, I live and learn. But two things happened as I was doing what I was doing. I stole out the store and the police came up to me, which they didn't bring me to jail. He told me this one thing. He said, you didn't have to do this. They would have gave you the food. And then showed me instead of stealing, I could just ask. And then another time I was panhandling on College Street at the burrito place. And across the street was a car wash. And instead of me, and I looked and I thought about something. And I crossed the street and I started asking them to wash their cars. So what I'm getting at that is, it's better to work than to be doing all that. You know, it's a different way that I'm gonna go by doing things this time, you know,
How old are you?
45.
Yeah, time to start doing things
Yes,
different, huh?
ma'am. Yes, ma'am.
Anything else?
No, Judge.
So here's the thing, Mr. Johnson. If I give you an opportunity today, it's probably gonna be, the worst I could do today is give you 5 years in prison if I sent you to prison.
Wow.
You'd be out in 2 or 3 years and that'd be it. If you really want to change your life and you want probation, it's going to be for a longer period of time. And if you violate, the sentence could be for a longer period of time.
Yes, ma'am.
It's going to require safety so that you can have the tools to be successful, to not turn to alcohol and drugs and things like that. So I'm going to kind of leave it to you. If you really want that opportunity, I want you to take it. I'll give it to you today based on, you've been very upfront. Your history is all clearly because of homelessness and drugs. I mean, that's clear. So if you want to change, I'll give you that opportunity. Is that what you want?
Well, probation.
Mm-hmm.
Yes, ma'am.
Okay. So here's what I'm going to do, Mr. Johnson. I'm going to find that you entered your plea of guilty freely and voluntarily previously. Find sufficient evidence to find you guilty, and at this time, find you guilty of theft of property with previous convictions. Find those prior convictions that you pled true to, true. Sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that. You'll be placed on probation for 10 years. You'll be ordered to follow all of the rules and conditions of probation.
Yes, ma'am.
That is going to include entering and successfully completing the SafeP program. So you'll go to the inpatient part of SafeP in custody, and then you'll get out, you'll have aftercare. All of that's going to help you find a place to live, get hopefully a job, stay clean, do everything you're supposed to.
Right.
If you do everything you're supposed to, then for all practical purposes, your case here in court's over. You'll be able to serve that 10-year sentence while you're out on probation. But the other side of it is if you violate your probation, I'm going to see all this history. I'm going to wonder why I gave you this opportunity, and you're going to end up with that 10 years that I just gave you. You understand?
Yes, ma'am.
All right, so I'm going to hand you the trial court certification that shows this was an agreement that I followed. So you have waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you, Mr. Dinkin, Mr. Smith went a little light on the chances that you've been given. Because when you were placed on probation back in 2019, started off decent, and then it looks like in 2022, and you were 39 years old in 2019, so it's not like you were young and you've learned something and, you know, you were a kid when this started. You started testing positive for cocaine back in 2022. You were referred to the ATAR substance abuse program, did not comply with all of those directions, so you were given help then. Another administrative hearing was had September of 2022. You tested positive again for cocaine. Even though you had previously been given that opportunity to go through the ATAR program, you had made no effort to enroll in it. So I got a memo, I'm sure, that said to send you to ISF, which I did. And you went through both tracks of ISF, the cognitive and the substance abuse track. And the end of 2022, you got out 2023. You started testing positive for alcohol within a month of getting out of ISF. And you were then referred to the DROP program to help you, even though you had just gotten out of ISF and you never showed up and you've been gone ever since. So I don't know what other options or things we could do for you. You've been given every opportunity to have whatever treatment you need to be able to stay out, take care of your family, as you say. But that's not what you've been doing. So, I mean, you've been gone since 2023. Anyway, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon to a family member. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative and given Mr. Phillips an opportunity. Is that correct?
Yes, ma'am, correct.
Maybe not jumping up and down for it, but not completely opposed to it.
Yes.
Okay. Ms. Malfino? Thoughts
Judge,
on that?
I would defer to what the court deemed appropriate. I know in Mr. Smith's review of it, in the alternative, he thought 5 years in prison would be appropriate, and maybe it would just assist in saying that to the defendant, that if we're back, it will be more than.
Oh, no doubt. I mean, I would assume. I can't obviously say for sure.
Right.
I guess what we're set for primarily today with this time was because we were potentially going to have that new offense.
Right.
Okay, so we don't have that.
Right.
Mr. Phillips, if I give you this opportunity, number one, there aren't any other things to do. You will have had everything we have to offer at that point. If I send you to safety, we will have spent probably over $100,000 on you individually for this help. Do you understand
Yes.
the opportunity? And I don't want you to go take this bed from someone else and not take advantage of it, because that's what you've done so far. So if you really want this opportunity, then it's time to take advantage of it. And you'll be on zero tolerance. There will be absolutely not a single mistake you can make on probation, or you will be back in here and you will be looking at, was it a 5 over 5 or what was it? No, it was a
I don't
10-year
believe
sentence.
so.
You've already agreed to a 10-year sentence.
You know.
So we don't even have to have a hearing. No one has to offer anything or say anything. I'm telling you now, you'll get your 10-year sentence. You've already agreed to that. This is a convicted probation. There's no thought process that any of us have to have if you violate again. You understand that? And I'm sure Miss Malfino will make a notation. If we're back here, she'll remind me of that. And I'll have this pre-sentence report that I've looked at, and it won't be good, right?
Yes.
All right, so what I'm gonna do then is find that you entered your pleas of true to counts 2 through 6 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, but I'm not going to do that. I am going to continue you on probation. I am going to extend your probation for 3 years and order that you enter and successfully complete the safety program. Whatever aftercare probation thinks is necessary, if it's the JCDI program or some other aftercare, you'll be required to do it so that you can continue to make good decisions and get this probation over with. Again, if you do that, then your case here in court's over. You'll get to serve that 10-year sentence while you're out on probation. If you don't, you will be again on the zero tolerance. And that means if you violate, you'll be back in here and you'll be looking at that 10-year sentence, right? Obviously, there wasn't an agreement. You do have some rights to appeal. I can't imagine that you want to do that, but I'm going to hand you this certification that shows, and I need y'all to sign that, and you can give him the bottom copy. Thank you for being here, and thanks for covering.
Yep.
I'll get these orders and I'll let you know. Also, and I don't know, I know there was some issues, when I read this with the self-medication with maybe some mental health issues. I don't know if there's enough for him to,
We didn't have any proper, like actual diagnosis. It was just more from conversations.
so I don't know if we want to do an evaluation just to make sure that special needs safety wouldn't be more appropriate. It may not be, but, if y'all can just look into that,
Okay.
but one or the other. Thank you, ma'am. All right, thank
And I'll
y'all.
get that order. I'll get him to sign it and I'll think it's.
Thank you, ma'am. Thank you.
Right,